These Patriot people.
Oh, yeah.
Yeah.
Was it going to be 5 today?
9. I got 9 so far.
Okay.
Welcome, my fellow Patriots. I'm Judge Michael Warren, co-creator of Patriot Week and host of Patriot Lessons, American History and Civics podcast. We are very excited that you're joining us for our second annual and first virtual Patriot Academy. President Ronald Reagan reflected, "Freedom is never more than one generation away from extinction. We didn't pass it on to our children in the bloodstream. It must be fought for, protected, and handed on for them to do the same." Taking a good look at our country today, there are many out there that don't appreciate the unique blessings of America, or actually despise it. We need to protect our freedoms, just not for ourselves, but for our children and their children. Well, Patriot Week is the antidote to that disheartening and ignorant attitude and a way to protect the true America. Patriot Week renews America's spirit by deepening the appreciation of our founding first principles, founding fathers and other great patriots, vital documents and speeches, and flags that make America the greatest nation in world history. Many of our current holidays have become over-commercialized or have lost their deeper meaning. We need to reinvigorate our appreciation and understanding of America's spirit. Anchored by the key dates of September 11th, the anniversary of the terrorist attacks, and September 17th, Constitution Day, the anniversary of the signing of the Constitution, the schedule for each day has a separate focus. Patriot Week started in 2009 when my then 10-year-old daughter Leah pounded on the table and demanded a new celebration for America. Patriot Week has been recognized by the US Senate in a unanimous resolution, and I believe a new resolution was just unleashed today, as well as by over 15 states with official gubernatorial and legislative proclamations and resolutions. Scores of K through 12 schools, including public, charter, private homeschools, universities, law schools, student groups, community organizations like Kiwanis, Rotaries, senior centers, religious and others, cities, counties, courts, law firms, businesses, senior living communities, libraries, hospitals, historical groups, private homes, public officials, and other engage in a wide range of grassroots activities, including panel discussions, speakers, lesson plans, festivals, parades, picnics, commemorations. We even hosted a gubernatorial debate. Tomorrow is Constitution Day, and we're hosting over 200 students at the Oakland County Circuit Court virtually. And we have a virtual toast to the Constitution at 5:30 p.m. Eastern Standard Time, which I hope you can make, along with our final installment of this year's Patriot Academy, again at 7 o'clock Eastern Standard Time. Today, we are discussing the themes of September 16th. On 9/16, we commemorate the unique first principle of unalienable rights, the towering figure of Thomas Jefferson, the groundbreaking Bill of Rights, as well as the Gadsden flag, which is behind me, known for its snake and its slogan, "Don't tread on me," which you can kind of see there. We'll be talking about that, obviously, in just a few minutes. We'll begin by addressing the first principle of unalienable rights. America was unique in the course of human history because when we declared independence, we did so in defense of certain founding beliefs, what we call the first principles. And each first principle is an indispensable cornerstone of the American Republic. And each must be well understood to secure our freedoms and continue the success of our grand experiment in self-government. At the core of those beliefs, they are laid out in the second paragraph of the Declaration of Independence, which declares, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That when any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness." From those eloquent sentences, we can identify 6 first principles: the rule of law, unalienable rights, the social compact, equality, limited government, and the right to alter or abolish an oppressive government, that is revolution. Throughout this academy, we have been addressing each of these in turn. The Founding Fathers recognized as a self-evident truth that all men are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. This precept was nurtured in the Founding Fathers by John Locke and other English natural law philosophers. Jefferson explained the essence of the founders' understanding regarding this principle. Quote, "A free people claims their rights as derived from the laws of nature and not as a gift from their chief magistrate," unquote. That this principle forms much of the philosophical bulwark of our founding is evidenced by its recognition of the, in its recognition, not only the Declaration of Independence, but in the state constitutions adopted during and in the aftermath of the Revolution. Thus, a basic maxim of American government is that some rights are derived from nature and they may not be taken away or violated by the government. This first principle and its sources turn topsy-turvy the prior understanding of authority and rights. Putting aside a few ancient democracies and republics, kings and nobility historically were the origin of authority, that is the sovereign, and they granted rights and privileges to their subjects. The privileged class was the sole power and authority, and the people held their liberties at the pleasure of their rulers. Even in England, perhaps the most enlightened country at the time of the Revolution, the king was considered supreme. While the House of Commons was, in a limited sense, intended to recognize the rights of the people, it was only one of three branches of government, and both the monarchy and the House of Lords possessed enormous authority that was derived from blood and heritage. Although the radical Whigs in England and a smattering of English parliamentarians embraced the concept that the people were or should be sovereign, nearly no one supported abolishing the monarchy and the House of Lords, and both even exist today. The political reality in England and across the globe at the time of the Revolution, and for most of world history, was that the people were not the sovereign, but the ruled. That is why residents of the British Empire were referred to as citizens, that's why residents of the British Empire were not referred to as citizens. They were subjects. Nevertheless, America boldly proclaimed at its birth that some rights were endowed by man's very nature, and that individuals are incapable of relinquishing them. Because these rights are endowed in the people from nature's God, they are inherent in each individual and cannot be abandoned. In other words, such rights are unalienable. Alienability is an old-fashioned term for being able to sell or give away or transfer something. If it's unalienable, that means you can't do that. Those unalienable rights are so important and intrinsic to humanity that no person can forfeit them by simply consenting to live under the rule of a government. John Dickinson, an early American colonial opponent of tyrannical British actions, powerfully expressed this understanding in 1776. "We claim rights essential to happiness from a higher source, from the King of Kings and the Lord of all the earth. They are not annexed to us by parchments and seals. They are created within us by the decrees of providence, which establish the laws of nature. They are born in us, exist with us, and cannot be taken from us by any human power." John Adams likewise explained that the people possessed rights that were, quote, "undoubtedly antecedent to all earthly governments." That means before all earthly governments, rights that cannot be repealed or restrained by human laws, rights derived from the great legislator of the universe. Like many other state constitutions adopted during and after the Revolution, the Virginia Bill of Rights, drafted by the influential revolutionary leader George Mason and adopted just prior to the Declaration of Independence, proclaimed that all men by nature have certain inalienable rights, of which when they enter into a state of society, they cannot by any compact deprive their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property and pursuing and obtaining happiness and safety. In other words, the sacred rights of mankind, Alexander Hamilton observed, are not to be rummaged for among old parchments or musty records. They are written as with a sunbeam in the whole volume of human nature, by the hand of divinity itself, and can never be erased or obscured by mortal power. Thus, the recognition and protection of unalienable rights is a centerpiece of America's first principles. This was a revolutionary concept in human history. Remember, before 1776, our governments just dribbled out privileges. You were the servant of the government, not the other way around. This idea of unalienable rights, however, needed real people to bring it to life. Patriot Week board member David Hansma will lead us in our next portion of the Academy and discuss Thomas Jefferson. David will introduce himself and then shine the light on this enormously influential leader. David, the floor is yours.
Thank you, Judge. My name is David Hansma. I am an attorney at Seaborn Kahn in Southfield, where I practice business law and commercial litigation. I'm also on the board of directors of Patriot Week, and I serve as the director of governmental relations for the organization. And I'm very glad to talk to you today about Thomas Jefferson, who was one of the leading founding fathers and a very appropriate person to talk about today with the subject of unalienable rights. Jefferson was far from perfect, as we will soon hear, but he was also one of the most important figures relating to the first principle of unalienable rights. So let's start with some biographical information about Jefferson and then talk about what he has to do with unalienable rights. Jefferson was born in Virginia and studied at the College of William and Mary. He was a voracious reader and studied everything from politics and philosophy to architecture and agriculture. After finishing college, he started his career as a lawyer. He then served in the Virginia legislature. After a time in the Virginia legislature, he was a delegate to the First Continental Congress. And during his service with the Continental Congress, Jefferson cemented himself in history by writing the first draft of what became the Declaration of Independence, which subject we will return to in a moment. During the Revolutionary War, among other things, he helped draft the Virginia Constitution and the Virginia Statute on religious freedom, and served as governor of Virginia. He then served as the United States First Minister to France. During the administration of President George Washington, he served as Secretary of State. He was vice president under John Adams, and then elected president in 1800, which office he held until 1809. After the presidency, he continued to write, including voluminous correspondences with other revolutionary figures, including John Adams, until he and Adams died on the same day, appropriately July 4th, 1826. So, when we ask, what does Jefferson have to do with unalienable rights? The obvious answer is that Jefferson was the primary author of the Declaration of Independence, including the unforgettable statement that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. One historian has called the Declaration Jefferson's preeminent contribution to the world, which I think is pretty much inarguable. As Judge Warren's presentation made clear, Jefferson did not come up with these ideas himself, and the words he used are actually pretty similar to statements made by John Locke and George Mason and others. But the enshrinement of these ideas in the Declaration is what we remember today. So then we ask ourselves, what in particular did Thomas Jefferson mean by these words? And a lot of that can be answered directly from the text of the Declaration. Jefferson says that we are endowed by our Creator with these unalienable rights, meaning these are rights we have from God. And for Jefferson, a well-known deist who was not particularly religious, the emphasis is not really on God. The emphasis is that these are rights that are not granted, but rights that are inherent to mankind. These are rights that even precede the rights of Englishmen that the colonists often cited in favor of their freedoms and that existed by ancient custom and constitution. The unalienable rights precede even those ancient rights. Second, the Declaration says, among these are life, liberty, and the pursuit of happiness. So to Jefferson, life, liberty, and the pursuit of happiness are not exclusive. Instead, they are intended to be broad, demonstrative rights, but not an exhaustive list. I think this is demonstrated by the word liberty. Think about how broad that is and how many rights and freedoms fall under the term liberty. Rights such as the rights of conscience and religious freedom that Jefferson held dear. The unalienable rights also included, according to Jefferson, the right to abolish governments and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. This was a radical statement at the time. It is still radical today. But Jefferson would have actually gone even farther. He once famously said that earth belongs in usufruct to the living. He did not think that one generation had any right to decide how the next generation would be governed. Instead, he thought that the Constitution should be rewritten every generation, which he measured as being about every 19 years. So to his mind, every 19 years, there should be a revision and rewriting of the Constitution, which in my opinion would be an absolute disaster, but it shows how radical Jefferson was regarding individual rights. But that brings us to the enormous elephant in the room. What do we do about the fact that Jefferson owned hundreds of slaves? What do we do with a man who spoke passionately about rights and liberty, who also sometimes spoke passionately against slavery, and yet owned slaves himself? A man who did not have the courage of his supposed convictions. Should we cancel him, to use the modern vernacular? No one asked me, but my answer is no. Paradoxically, I think the desire to either ignore Jefferson's failings or to cancel him altogether both make the mistake of treating our founding fathers as gods. God can't sin, so with Jefferson, we must either gloss over and ignore his sins or throw him down altogether. But Jefferson, like all the founding fathers, was not a god. He was a man. And we do not celebrate him for his own sake. What we celebrate about Jefferson is not the sometimes hypocritical, feckless, indebted, vindictive man that he could be and that historians tell us about. What we celebrate about Jefferson is what he achieved for posterity. In a famous provision of Jefferson's draft of the Declaration of Independence, a provision which was later cut by the larger committee over Jefferson's objection, he specifically denounced the slave trade and referred to slaves as men, which was almost certainly intentional. Though he never lived up to it, in his draft of the Declaration, he recognized that slaves fell into the same category as those who enjoyed unalienable rights, i.e. men, mankind. Though the explicit statement was removed from the Declaration, this conclusion is still inescapable from what remained. And it was Jefferson's Declaration of Unalienable Rights that gave the moral argument adopted later by Lincoln, Frederick Douglass, and others for the abolitionist cause. And it still gives the moral argument for the rights we enjoy today, and is one of the first principles that makes our modern conception of rights worth the paper that they are written on. Imperfect though he was, Jefferson's single phrase of unalienable rights has perhaps done more for the freedoms of all Americans, no matter their race, than any other founding achievement. And with that, I will hand it back to Judge Warren. Thank you.
David, thank you for your excellent presentation in connection with Thomas Jefferson and the great conundrum that he has been for America for such a long time. It's amazing what his life was, not just about the Declaration of Independence, but everything else that you mentioned, and thank you so much. Our next topic is the Bill of Rights, which guarantees many of our unalienable rights. The Supreme Patriot, Christina Bilowis, will present herself and review the Bill of Rights as well. Christina, the floor is yours.
Thank you, Your Honor, for having me on the presentation today. I am an attorney with Kizzy Law in Southfield, Michigan, where I mostly practice family law, and it is my pleasure to speak today about the Bill of Rights. Before we go into detail about what that entails, let's talk a little bit about the history. We know that the Bill of Rights comprises the first 10 amendments to the United States Constitution, and they were proposed following what is often thought of as a bitter debate of 1787 through 1788 over the ratification of the U.S. Constitution. And it was written to address the objections which were raised by anti-federalists. The Bill of Rights amendments adds to the Constitution specific guarantees of personal freedoms and rights, clear limitations on the government's power in judicial and other proceedings, and provides explicit declarations that all powers not specifically granted in the U.S. Congress and the Constitution are reserved for the states of the people. And these concepts are codified in these amendments and built upon those found in earlier documents. Those earlier documents could be the Virginia Declaration of Rights in 1776, as well as the Magna Carta of 1215, and as well as the English Bill of Rights in 1689. And they relied on these principles and underpinnings to form the Bill of Rights. They're due largely to the efforts of a representative of James Madison at the time, who studied the deficiencies presented in the U.S. Constitution that were pointed out by anti-federalists. And then he crafted a series of corrective proposals. Now, Congress at the time approved 12 articles of amendments on September 25, 1789, and submitted those to the states for ratification. Now, contrary to Madison's proposal that the proposed amendments be incorporated into the main body of the Constitution, as opposed to relevant articles and sections of the document, these were proposed as supplemental additions to it. Articles 3 through 12 were ratified as additions to the Constitution, and that ratification occurred on December 15th of 1791, and they became Amendments 1 through 10 of the Constitution. However, Article 2 became part of the Constitution on May 5th, 1992, and as the 27th Amendment. However, Article 1 was never ratified and still is pending before the states. And although Madison's proposed amendments included a provision to extend the protection of some of the Bill of Rights to the states, the amendments that were finally submitted for ratification applied only to the federal government. The door for that application upon state governments opened in the 1860s, which followed the ratification of the 14th Amendment. And since the earlier part of the 20th century, both federal and state courts have used the 14th Amendment to apply portions of the Bill of Rights to state and local governments. And this process, as we know it today, is called incorporation. And as a keynote to know, the Bill of Rights, there are several engrossed copies that are displayed in the National Archives in Washington, D.C., should anyone want to take a field trip. Now let's talk a little bit about what is entailed in the actual amendments. The First Amendment deals with religion, and it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievances. Amendment 2, we know also has to do with the right to bear arms. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3 is not one we may often think of, but it has to do with quartering of soldiers. And it says as following: no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in the time of war, but in a manner to be prescribed by law. The Fourth Amendment deals with the freedom from unreasonable search and seizure, and states as follows: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fifth Amendment, which we also know to this day, is the right of due process. It states as follows: no person shall be held to answer for a capital or otherwise infamous crime unless in a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when, in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case be a witness against himself, nor, be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Sixth Amendment has to do with criminal matters and the right to a speedy and public trial. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The Seventh Amendment deals with civil matters. In suits at common law where the value of controversy shall exceed $20, the right of trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So thus, the right to a jury trial in a civil matter is Amendment 7. Concerning the Eighth Amendment, it's the freedom against cruel and unusual punishment. And it says, excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Ninth Amendment has other rights of the people and says as such, the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And then finally, the 10th Amendment deals with powers reserved to the states and says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Now, in sum and substance, the Bill of Rights deals with issues that we are concerned with this day and has become the rule of law in often many states that we have adopted and are the underpinnings to our judicial system and also our criminal justice system as well as to the other rights and freedoms we enjoy to this day. And it was my pleasure to speak a little bit about this today. Without further ado, I will turn it back over to Judge Warren. Thank you.
Christina, yet another fabulous presentation, this time about the Bill of Rights. I really appreciate you and David stepping up to the plate and doing your sections of the presentation today. It's been fabulous. Obviously, we're just scratching the surface with with all the things that we're doing here. So I'd just like to remind people that there is patriotweek.org, which has much more additional information about all these topics that we're talking about. Our next speaker is Patriot Board member John Wilson. He will review, is John here? I want to make sure he's
yes, I am here, Judge.
Excellent. And he's going to review the Gadsden flag, which is the flag behind me. So I'm going to move out of the way of the flag for a second before I turn it over to John, because he's going to be pinned when he starts speaking. And I want everybody to take a good look at what this flag looks like, because then his presentation will look a little bit more sense when he moves forward. So there you go. That's our flag. And John, the floor is yours.
Okay, thank you, Judge. Yes, I apologize for the last 2 nights, but I am doing better. I did a presentation earlier today and I didn't cough, so I feel good. I'm very excited to—
Oh, John, can you move your camera just a little bit? We have a great shot of your forehead. There you go. Now we can see you.
Okay, thank you.
Thank you.
Yeah, very excited to present on the Gadsden flag, which, certainly in modern times has a lot of misunderstanding regarding the history and origin of this flag. And it is a perfect flag for this first principle of unalienable rights because of as Christina just so eloquently talked about, the Bill of Rights, our rights that are in between us, we the people, and government, and the possibility of tyranny, our civil liberties. And so in that context, and in the context of the origins of the revolution, I'm going to talk about the Gadsden flag. The Gadsden flag is a historical American flag with a yellow field depicting a timber rattlesnake, coiled and ready to strike. Beneath the rattlesnake, resting on grass, are the words, "Don't tread on me." The flag is named after American general and politician Christopher Gadsden. who designed it in 1775 during the American Revolution. It was used by the Continental Marines as an early motto flag, along with the Moultrie flag. And in a moment, I'll talk a little bit about that flag as a standard on one of the earliest naval ships. Again, think of this where we go forward here in terms of our inalienable rights and civil liberties. The bright yellow Gadsden flag, long a symbol of support for civil liberties and disagreement with government, has its beginning deeply rooted in the days of the American Revolution. The rattlesnake, the Gadsden flag's central feature, had been an emblem of Americans even before the Revolution. The Pennsylvania Gazette published an article in 1751 attributed under a pseudonym to Ben Franklin, bitterly protesting the British practice of sending convicts to America, where the author suggested that the colonists should return the favor by shipping them a cargo of rattlesnakes. 3 years later, the same newspaper published what is believed to be one of the first political cartoons in America. It was of a snake cut into 8 sections with the words "join or die." Again, a reference to the fact that unity of the colonies was critical if they were to survive. Each section represented a colony and was warning of the dangers of disunity. Now, the rattlesnake is a very important symbol, and I think you'll see this as we talk about the timber rattlesnake. It was only to be found in North America, no other part of the world, and so it was uniquely American, and it was prevalent throughout the 13 colonies, particularly in the forests of the southern colonies. The timber rattler's reputation was not that of an aggressor, but if provoked, it would provide a warning with its rattles. And if the warning was not heeded, it would strike to the death. Isn't that a kind of a description, if we're picturing the tyranny of the monarch and what led to the revolution and Jefferson's writing and the Declaration of Independence? I'm going to read that again. The timber rattler's reputation was not that of an aggressor, but if provoked, it would provide a warning with its rattles. And if the warning was not heeded, it would strike to the death. This was a perfect symbol for the position of the revolutionary posture of the colonies and the founding of our nation, determined to unburden the tyranny of the British monarchy and the road to liberty. Further of interest is that the timber rattler actually has a total of 13 rattles in its rattler. Perfect symbol for the unity of purpose of our great nation at its start. The phrase, "Don't tread on me," corresponds to the symbol. Tread on us and we will strike. The flag, again, was designed by the South Carolina politician Christopher Gadsden. He gifted the flag to Captain Essex Hopkins, one of the original Marine ship captains for the Continental Marines. He flew the flag on his ship as its standard. In fact, to this day, the Gadsden flag is a formal symbol of the United States Marine Corps. Judge, that's my presentation.
Another fantastic presentation. Just think about that, ladies and gentlemen. We're talking about, just give me a second. I know I can find myself. There we go. We're talking about unalienable rights, which means that our rights come from God. And then we have a rattlesnake, which represents that, with 13 different segments in the rattlesnake. It's in the rattle. It's just amazing. And this segues into what I was going to say next. And one of our consistent participants has already jumped the gun, which is great, which I was going to say, we do have some extra time today. And if you have questions, you can use the chat function. You go down to the bottom of your screen and you'll see in the middle of the bar chat with a little bubble, and you can send a question, and then we can answer the question if it's appropriate. And we do have an appropriate question, which I'm going to run to, which is from David. And he says, as a devout Christian, I believe that God inspired the founders in their sacred duty to establish a governing constitution for America, this promised land. In their speeches and writings, most of the founders include comments alluding to God's role in establishing this nation. My question is this: did the founders themselves feel that they were being directed by a divine influence? I wish I had that question a few minutes before we started, because the answer is absolutely yes. I just don't have the quotations before me to be able to muster my answer. But there is no question that many of the founding fathers, not gonna say all, but that many of the founding fathers thought that the divine hand of providence was supporting them, and that several different times during the course of the revolution, they felt that it was the hand of providence that allowed them the victory. And there were several times when Washington's troops were in grave circumstances, and a mysterious fog would appear and obscure the ability of the English fleet to chase them. And that happened more than once. And often you'll see portrayals of Washington in his army dress uniform, actually his field uniform, praying fervently to God to help him and his troops win. And I think that was a consistent theme. If you've been listening to the podcast, we haven't really talked about it much here, but the Patriot Lessons, American History and Civics podcast, there are a number of preachers, colonial preachers, who were very important and instrumental in the revolution. Think of them as your media personalities for today. You know, they didn't have TV, they didn't have radio, they didn't have the internet. There were a lot of community organizations, but the place where everybody would meet, or at least large numbers would meet in different locations, were churches. And there was a whole host of preachers that preached in defending our unalienable rights. They understood the social compact, understood that our rights came from God. They very much believed that. They were very concerned that the British were destroying the rule of law, undermining unalienable rights, infringing on the social compact, denigrating equality, all the great founding first principles that we believed in, and said we must resist. And several of them said we must, we shouldn't cower in fear. God has given us these rights, and if someone's taking them away, we have a duty, a sacred duty. And you'll see this language appears in the Declaration, a sacred duty to protect those rights. So they said if someone is depriving you of them with violence or force, you can meet force with force and violence with violence. It's basically a straight up quote from one of them. So getting back to the broader point, many of the founders believed that divine providence was moving them forward through the revolution and then through the Constitutional Convention. I'd say more the revolution than the Constitution, but clearly I think they felt that America was the beacon of hope and the torch of liberty by divine providence, that they had this obligation to preserve it the best they could, and they saw the Constitution was the way to do that. So to answer David's first question, the answer is yes. I'm sure there were some founders that were, even somebody like Jefferson, who kind of believed in a clockmaker of God, so to speak, someone that didn't necessarily always intervene and speak directly to people and those kinds of things. Even he, if you take the Declaration seriously, believed that this was ordained by God, that they had to do this, and that the destiny of the nation was to fight for freedom and liberty. David's second question is: the freedom of religion is enshrined in the First Amendment. As far as I understand, nowhere does the Constitution declare or even allude to the separation of church and state. Most of us understand the government should never create or favor a particular church or sect, but how did the separation of religion, not church, creep into the public interpretation of the Constitution? I'm willing to take a stab at that, but Christina, you covered the Bill of Rights, so I don't know if you wanted to touch base on that. But
No, I think you've covered it very eloquently, Judge.
okay, so on this one, what's happened is, and we should take a step back. And I'm going to talk about my book, and just mention that I have a book. But if you read my book, you'll note that there is a whole chapter dedicated to the fact that America was settled for the purpose of freedom and liberty. I mean, there were some people that were trying to get money, and some people were trying to escape the poverty of Europe, but most of the people, the leaders, really were trying to find a haven in America from religious persecution and religious persecution. And so when they first came over, they were looking for religious freedom. And eventually that developed in the colonies to become the disestablishment of a state church from the colony. So it's interesting, of course, people flee and then they take power in their colony, and then they often would persecute people that were religious dissenters within their own colony. So the persecuted became the persecutors, and eventually that hypocrisy and the concern over religious strife that had inflamed Europe for centuries, between Christians fighting different sects within Christians, led to a movement to allow for, number one, the free exercise of religion, which is that you can worship God the way you want, and number two, to not allow for a state established church. So there used to be churches that was the state church, and people had to pay taxes to fund the state church. And you could see why that would be controversial, because if you were, let's say, Roman Catholic, which was a distinct minority at the time, and you were being taxed to support a Baptist church, which thought that the Pope was the Antichrist, and some of them were that extreme, that could pose serious problems. So there was a dual-fold protection of liberty, free exercise, and disestablishment of the church. Now, originally, the disestablishment of the churches started in the colonies. It started in Virginia with the religious, there was a statute for religious freedom that was passed, written by Madison, proposed by Jefferson, ushered through by Madison, and that was the first really constitutional barrier for an established religion in the whole world. So this is another thing that's monumental that the founders are doing. And when the 14th Amendment passed, so the First Amendment, when it was passed, was written by Madison, and he put in the Bill of Rights that there'd be no national church. But no one interpreted that to mean that there would be no state churches. So that disestablishment took decades, but eventually by the early 1800s, all the state churches have been disestablished. But then we had passed the 14th Amendment, and the 14th Amendment was interpreted by the Supreme Court to apply the First Amendment to the states. And so, and they had a very robust, broad view of what establishment was. And they took some letters from Jefferson, and Jefferson clearly was an absolutist in this. He didn't want any money to go to a church. He was very exacting on that. And so I like to say, I'm sorry, this is a long-winded answer. If you look at the founding fathers, the intentions and the purpose behind the First Amendment, and any provision is kind of like a football field of reasonable debate, and not everyone agrees. And so long as you're playing on that football field with the same rules, you will come out to a just result. And then what happens, sometimes the Supreme Court, in my view, has gone off the football field, and they're playing some other game, or they're ignoring the football field, they're playing baseball or whatever, and you're like, wait a minute, you're supposed to be on the football field. The robust view of total separation of church and state is actually supported by some of the founders: Thomas Paine, Jefferson, Madison, to a lesser degree than Jefferson, but to a very strong extent. But then it got so expansive that I think there's some real question about whether even Jefferson and Madison and Paine would go that far. So it's really the Supreme Court that's done it. They've used these some supporting documents to move it to a very expansive view. The Supreme Court's now kind of cut that back significantly. For example, you can now have school vouchers that go to religious-based schools, and that would not have been the case just until very recently. So this is an area of great debate. So it's the best I can give you. Bill asked everyone, is in the First Amendment doesn't say anything about the separation of church states. However, this is often meant to keep religion out of government. Can you comment on this difference, either noting how we got there or what we can do to change back to the original wording? So again, I think that's pretty much covered in my comments. I'll highlight a couple of other things. Congress has acted when they thought that the Supreme Court went off the rails. And so they passed a law called the Freedom Restoration Act. There was a Supreme Court decision called Smith versus Employment Agency, or Employment Agency versus Smith, which way it was. And they reduced the protection of the free exercise of religion, and then the Supreme Court generated backlash. And so the way to deal with some of these issues would be, the Congress did fix part of that issue, is to go, and Michigan has a Freedom Restoration Act. So the way to, if you're concerned about some of these things, is you can actually pass legislation that will survive constitutional muster. I think you can lobby, you can amend the local constitution, like we have in Michigan several times, or even the U.S. Constitution. That's a real heavy lift, but it's been done 27 times. Or affect who becomes the nominees of the Supreme Court by affecting who becomes the president and who sits in the Senate. So it's a very diluted way to affect, but nobody can just say, oh, that's wrong, and it changes. It's a system built in for that. All right, then we have from Patrick, what is the definer of inalienable rights? Supreme Court law, people, or God? Well, that's a great question. So the Supreme Court rarely uses the word unalienable rights, because what they're looking at is the document of the Constitution. We're talking about, or a statutory protection of rights. We're talking about the undergirding philosophy. And I think that is, in the end, it's really defined by God. Is what does God put into you as a human being? What rights do you have? How that manifests itself can come through the law or the people or the Supreme Court. For example, we have the right to freedom of association, to assemble, to express ourselves the way we want. That's been protected by the Bill of Rights and the free speech and press clauses, the right to assembly clauses, and then it's up to the Supreme Court to protect those. So God gives us the rights. The people have adopted the Constitution. The Supreme Court's supposed to enforce the Constitution. So all those, it all has to work together. Otherwise, we go off the rails and we violate our rights. And so it's extremely important. It's why we're having this kind of academy, is for people to understand the basis of their rights, so that they don't have the mentality that they have to go to government and beg for their rights. And I think that's become the prevailing ethic for many people in this country, that the government controls and they dribble out our privileges. And that's the exact opposite. And if we can get back to the principle, understanding from our students and our government and our people, that government is supposed to protect our rights, but they come from God or nature, nature's law, however you want to put it, then some of these decisions and laws would never be passed, because they understand, I can't do that. I don't have the authority to do that. But when you have this great ignorance or disdain for this idea of unalienable rights, and there's whole swaths of our media and our political culture that would be screaming at the screen, maybe they are now, saying, that's a bunch of baloney, and we don't have any of these rights, and it's all fake, it's all made up. That's a very dangerous attitude, because then we don't have any firm foundation. It's just sand. So I hope that helps. Didn't Jefferson, only one founder, say the people were the ultimate arbitrator? Again, the founders believed that the people were the sovereign that they should create the Constitution. And Jefferson did want this, David mentioned the 19-year reenactment or revisiting of the Constitution. I think all the founders believed God was number one. He gave it to the people. It was the people's responsibility to protect their rights. And the way that you did that is you created a Constitution and you held your officials accountable to living up to that Constitution. So there's several different layers there. And when the government doesn't live up to the Constitution, thereby subverting your unalienable rights, then, and they do that for a long train of abuses and usurpations with an object to oppress you, which is what the first day of the academy was about, then you have the right to revolution. People have to come back and they're ultimately accountable for preserving their own liberties. So it's very complex, but these are great questions. Another comment from Ed. Thank you for your, well, you can read that. I guess, let's see. How, by the 2020 standards, Jefferson may look suspect. How different would the atmosphere in the 18th century reflect upon Jefferson's shortcomings? So David, what did they think about Jefferson in the 18th century, in the 1770s and beyond, about his shortcomings today?
Well, I would say that depends on who you ask. There were a lot of people who were huge Jeffersonians. They were Jefferson fans. They would say he didn't have much in the way of shortcomings. His political opponents, obviously, like Hamilton and some others, they disagreed with him largely on political grounds that aren't the sort of shortcomings we think about now. When we look back on Jefferson and talk about his shortcomings, obviously the major one we're thinking about is the fact that he was a slaveholder. And back then he was very much in the mainstream of society. Very many of the founders were slaveholders. Jefferson was, Washington was, quite a number of those that lived in what was known as the South were slaveholders. Not, of course, not all of them were. John Adams, for example, I don't think ever owned slaves. A number of Northern founding fathers certainly did not. So the different atmosphere of the 18th century certainly is significant to that, because in his time and place, Jefferson was actually a radical in terms of having some abolitionist leanings. And as I mentioned, he never lived up to his what he preached. And again, I think that had something to do with the fact that he was not a very good money manager, and he was in debt a lot. And in the context in which he lived on a plantation, I just don't think he ever thought that economically he could afford to emancipate his slaves and continue to be the sort of upper class gentleman, farmer / philosopher that he was. But in his context, being a slaveholder, was normal. And actually it was some of his statements and speeches against slavery, especially the slave trade, which were the controversial parts. So I don't know if that answered the question. I certainly hope it did.
I think that was a very eloquent answer, and I think a very honest one. The other, just to emphasize, just one point that David made, and I think that we as Americans keep forgetting, and I think it's actually very, very important. And I do go through this in the Patriot Lessons, American History and Civics podcast. For most of human history, slavery was quite normal. I mean, it was the condition of life, that there were people that were nobility, there were kings, there were military rulers, whatever, they were in charge of the top of the hierarchy. There was a noble class, a religious caste. Most of the people were at kind of, the common people, 95, 98% were just kind of, at the bottom of the barrel with no rights or just a few privileges that were given. And that 98% might be 75% because 20% were slaves. And that was not race-based. It was not ethnic. It was simply a state of being in which it was accepted, and it was accepted worldwide, practiced in every country. And it really wasn't until the era of the revolution, American Revolution, that there was much traction at all about trying to get rid of this institution. And the words of the Declaration of Independence, we understand he was a hypocrite, but the words of the Declaration of Independence is really what propelled abolitionism and emancipation, but because those who started to see the injustice of slavery could point to a written document in the Declaration of Independence and say, this country supposedly is formed on equality, how can they have slaves? And that propelled our country in a different direction. Now, there were other countries that were, and other religious leaders that were making significant progress, but we really got a huge jolt because of that. So I think that we just need to remember that. I don't see any other questions. We're very close to the end of our time, and I keep promising that we're only going to be an hour, and I really appreciate it was great to have the engagement of all the questions. I think we had more questions today, and they were very insightful, and it's really very much appreciated. Remember that the idea of inalienable rights was revolutionary in the full scope of human history. And we have to remember that, or we're going to lose them. Fellow Patriots, I hope you enjoyed and learned something in the September 16th session of our Patriot Academy. Please return for our last session that's tomorrow on Constitution Day, which is the anniversary of the signing of the Constitution. We also have this really cool thing, a virtual toast to the Constitution at 5:30 p.m. Eastern Standard Time. If you are interested, you can register, but just go to our website and you can register for that, and we will open it up for people to give actual toast. I will look a little different tomorrow because of the garb I will be wearing. So if that gives you an incentive to show up and what is Judge Warren going to wear, I think you'll like it. Don't forget to check out our podcast, Patriot Lessons, American History and Civics podcast, as well as the Patriot Lessons TV show, which is on demand on our, it's broadcast locally, but it's also on demand on our website. We have lesson plans and daily celebrations. So if you're at home and you're just looking for things to do in connection with renewing the spirit of America, and you have some time with your family or friends or just by yourself. I know in this day and age, that's not that unusual. You can spend 5 minutes up to an hour going through various things and really getting a better understanding of our history and civics. So we have a lot to offer at patriotweek.org, so I just encourage you to go there. You can also follow us on Twitter, Facebook. By the way, Twitter they canceled us, but we got reinstituted. So we don't have a lot of Twitter followers right now. So we're looking to rebuild that base. So we have a Facebook page, an Instagram page, and LinkedIn. You also might want to check out my book, America's Survival Guide, How to Stop America's Impending Suicide by Reclaiming Our Founding First Principles in History. You can find that at americasurvivalguide.com, Amazon, and other online retailers. It's a great gift for young folks or college educated or someone that's 99. You can buy it early for Christmas and give it away. Lots of reasons to have it. But enough about that. We're so excited that you're here. Can't wait to return tomorrow. And until tomorrow, hopefully we'll see you at the toast and this last session of Constitution Day session of the Patriot Academy. God bless you and God bless America.